WMEL.
That's the sound of the 1951 Ford Victoria Hot Rod, fully restored and donated from the private collection of A.J. Hires. It's the 2017 Win the Classic Ford Car Raffle to support Helping Seniors of Brevard. You have to see this car. I'm Kerry Fink, and I'm inviting you to visit helpingseniors.brevard.org for full information on this exciting car raffle. That's helpingseniors.brevard.org. Stay tuned for more info on the Talk to Me Radio Network. We're glad that WMEL cares about the space and Treasure Coast.
The views expressed on the following program are those of the hosts, callers, and guests, and are not necessarily those of WMEL staff, management, or advertisers.
This is Joe Steckler, folks, your host for Helping Seniors, the radio arm of Helping Seniors of Brevard, the organization that has designed and has this mission to inform, educate, and connect seniors and those that care for seniors to resources here in Brevard County. That's our job. That's what we do. That's what we were designed to do, and that's what we are doing. So there's just a whole lot that you need to know. The number to reach Kay, who is our information specialist at the office, is 321-473-7770. That's 321-473-7770. And right before Bill Johnson's my panelist today, and we're going to talk about some legal things, some things that we don't generally talk about on the air, so you might want to get a pencil and paper out to jot down some of the things, because Bill's going to go into a few of the legal nuances that we don't really talk about sometime, and that can really trip you up if you're not really up to date on them. It can hurt us, especially as we get older. And there's just a lot we need to know, and we'll never know it all, remember it all, but we can do a better job of educating ourselves, and that's what we try to do. Some of the people that help us pay for the show, our sponsors, include the Eye Institute, Dr. Lee Sheldon, this radio station. Bill Johnson, my panelist today, is one of our major sponsors. Wistoff Hospital, Zon Beachside, Organized Creative Designs, Cobblestone Market Realty, Marker Street Memory Care, and a whole slew of people. And to see all the many wonderful sponsors, especially people that provide services to seniors, go to our website, helpingseniors.brevard.org, helpingseniors.brevard.org, all one word. So, having said all the commercial stuff, Bill, today we're going to talk about the dangers of do-it-yourself legal actions that citizens can take, and some of the legal technology that's out there now, and how some of it's good and some of it's bad, but a lot of it depends on how you use it, right?
Correct, Joe. It is let me back up. The main reason people do it yourself forms or legal work is because they want to save money.
Right.
And that's the overwhelming desire, is to, avoid having to go to an attorney's office and pay an attorney to draft up a corporation or a will, or, litigate for you, or do some legal research for you. And those are the four big areas that people try to go it on their own. And subsequently, there are times when that works. You can do it. But generally speaking, that only works if what you're doing is pretty simple. Once you start getting into more complex things, it can be troublesome, and that's kind of why we're having this topic on the air today.
Yeah, I remember all the years that you and I have talked on the radio and on our television shows, the articles you've written for me for the newsletter, the things you used to write for Florida Today. I've saved all those articles. I got probably close to 300 of them, and I think about all the mistakes that I, Joe Steckler, have avoided making simply because of the conversations that we've had like we're having today. I won't remember everything that you say, but I do know enough to say that, okay, I don't know that much about this topic, so I need to call Bill's office and find out what really is happening. Because I get a lot of phone calls, people ask me about where to go for a legal thing, what do I think about this? What do I think about that? And I got to be careful. I don't want to give somebody the wrong advice.
Correct.
So I call you and I ask if you'll talk to them, and you always do.
Right. One of the dangers, in do-it-yourself stuff is that you may not know all the rules, or you may inadvertently not perform all the things you have to do, and thus, in order to save a few bucks, you end up with a very costly mistake.
Well, look, let's just see if you open up like a whole wide area there. Let's say we're going to do something that you're talking about right now. We may answer 12 questions, but we leave the 13th out. Can you give an example of something that people we would think would be pretty simple, but if we fail to take one action on it, it could really cut us in problem?
Okay, a good example would be you go online and you are paying a company to prepare a will for you. So you go online, they ask you a bunch of questions, you fill in the answers, and then whatever program it is you're using online, it produces a document entitled a will. And then you download that will and print it out, and then you sign it, and you think you're done. Well, you forgot to sign it in front of witnesses, or they weren't in the room when you signed it, or they signed it the day after you signed it. So somehow you have a good document, but you messed up the execution of the document. And now, basically, your will is invalid. And if you have, some sort of a problem in your family where you're trying to leave things to certain people but not other people, you may have just, blown that up.
Yeah, because if one of the recipients of a beneficiary of the will inherits something, and another that falls under the same mistake clause, they have a right, or that gives them an area in which to contest the will.
Yeah, let's say you had 3 kids and you wanted to leave everything to 2 of them in your will, and then you don't execute the will properly. Well, now the will's thrown out and everything gets divided amongst the 3 kids. So you may have, created a problem for yourself or your heirs. Not necessarily yourself, because you're dead, but definitely for your heirs.
That's one way to look at it.
Yeah, you got bigger problems at that point.
Yeah, my wife worries sometimes about if we don't do all this right by the ones. It's like if we both died at the same time. If we didn't have it all right, there would be a problem for the kids. I said, that's their problem. It's not mine.
Another common error is you print out the will. Let's say you did a will. You print it out, and you're in your living room, and one of your children is there with you. You sign the will, and some other people witness the will, and you do everything properly, but that one child who was there helped you prepare the document, was there when you printed it out, and was there when you signed it. Well, under Florida case law, that is a prima facie case for undue influence. If you know what's in the will, were active in procuring it, were there when it was executed, knew the contents of the will beforehand, those are all elements of undue influence. So again, that will that you created where you're going to leave everything to your 2 kids and not to all 3 of your kids, again, that could be thrown out.
Well, a question a logical question I think comes about. Let's say I execute a will, and I have 2 people sign it. Years later, they go look at the will. What happens if they can't find, or do they try to find the people who signed the will?
Good question. Usually, you will have a notary who signs an affidavit, which is called a self-proof. And that is attached to the will, where the notary says they witnessed the testator and the witnesses signed the will. If you have one of those, the will is what we call self-proving, meaning that when you die, I don't have to go find one of the witnesses who saw you sign it. If you don't have that and your will is not self-proving, you just simply have your signature and the 2 witnesses, then I've got to get a statement, or what's called an oath of witness to will, where one of the witnesses will sign an affidavit, basically, saying they saw you sign the will. we can't get that, because sometimes you can't get that.
Right, I understand.
There are ways that we can go through. There are some other steps. The personal representative could sign an affidavit saying they believe this to be your true will, but it gets a lot more complicated. It also gets more complicated if we can't find the original, too.
Okay, two questions. The first question, I keep forgetting. I remember just a moment I asked you, I remember the darn thing. What happens if when you have the notary state that they watch the people sign it, make sure it's a legal signature and all that? You said attach a piece of paper. Wouldn't it have to be on the notarization would have to be on the same piece of paper that the witness signed on, wouldn't it? Because you could attach it.
It would be at the attached to it usually.
But see, it would seem to me if it was attached to it,
it would all have to have the same date, though.
Okay, all right. Okay.
And then if you had some question as to that, we could obviously ask the witnesses or the notary.
Okay, but now look at all the things that you and I have just described, all the actions that have come about because of an improper execution of the will. You have just added all kinds of an expense. Where if you'd have gone to a good attorney the first time, the chances are the legal will would have probably cost you a couple $100. You'd have had it done right, and you wouldn't have to chase yourself around all over the countryside trying to get us to go. And especially if you end up getting attorneys and billed by the hour.
Well, especially if you end up in litigation over the will. Everybody lawyers up, and then you can go through. I just did a litigation. It wasn't over a will, but it was over beneficiary designations and what we call a ladybird deed. But I think the legal fees on that thing alone were $100,000 or more, and the trial was 4 days long.
And you were involved in that?
Yeah. So, I mean, and there are ones that go even longer than that. So, it can get very, very expensive. Another common way that you challenge a will is lack of capacity. So just because somebody can go online, do a document, print it out, and sign it, doesn't mean that it can't be challenged. And if you have somebody with borderline capacity, again, the document may get thrown out. So unless you know to look for these things, or are looking for these things, undue influence, capacity, proper execution, just simply doing a form on a computer isn't enough.
I can see that.
Yeah.
What did I interrupt you? Remember what it was?
I do not. I know I was gonna jump over to incorporations, because that's another popular one where they will, online you can do an incorporation, or you can form a limited liability corporation or something, and you go online, you create this company, and then you're off and running, you think, and that's not necessarily the all that's involved with running a company. And so when you incorporate a company, you get a tax ID number, and then with your articles of incorporation, as they've been filed with the Department of State, and the tax ID number, you can open up a bank account. Well, that's all fine and dandy, but unless you go see an accountant, you won't know anything about payroll taxes or withholding or how you should even pay yourself. You won't know that you have to have annual meetings of the shareholders of your corporation. You won't know anything about how you have to act like a corporation. So there's a lot of pitfalls to simply going online, printing out a form again.
Do you do that kind of stuff in your practice?
Yeah, we do that kind of stuff. And we go through the whole rigmarole and, get them all set up to the point where they can get a tax ID number. We create bylaws, or in the case of a LLC, we create an operating agreement. We give them enough to get to the bank account, but then we tell them, you will need to go talk to an accountant the sooner the better. You should set up something like QuickBooks or Quicken to manage the checking account and keep records. If you're operating in the county, you will need to go get a county occupational license. If you're in a city, you'll need a city and a county occupational license. So, these are the things that just by filing a piece of paperwork and incorporating, you wouldn't know these things.
Why is it that many corporations are licensed in Delaware?
Because it has the most favorable laws to the corporations.
Of all the 50 states?
Yes.
Does anybody ever find fault by virtue of the fact that...
Because a lot of states have, shareholders have rights.
Right.
They can look at the books and all these things. And when you get to Delaware, shareholders have very little rights.
So how is that an advantage?
It's an advantage to the corporation.
Oh, I can see it, because,
Yeah.
The reason that I'm interested in this, folks, is because through my history of work here in Broward County after I retired from the Navy, I've actually set up 5 different nonprofits. Mm-hmm. So I realize the pitfalls, and everything that Bill has described is very true. But there's one other pitfall that's not a legal thing. It's called carelessness, with the change of some of the laws, we've made it a lot easier to get incorporated into form a nonprofit. But before those changes came about a couple of years ago, if you made a mistake, that could put you as much as a year behind in your filing process.
Yes.
Once you've made a mistake, the IRS is one of the most unforgiving entities in this country about trying to let you correct something.
And it seems kind of, that's kind of where I came up through that era. And nowadays, it seems you would have to do something like murder somebody before they take away stuff these days.
Yeah.
It seems that, a lot of the nonprofits that are also tax exempt are getting away with all kinds of stuff that you never used to be able to do. And I think it's probably simply because they don't have enough people to audit them.
I think you're exactly right. There's been much said in the last 6 months here in Broward County about nonprofits, and I think that there are something over 2,000 nonprofits right here in this little burg of Broward County, and does that mean that all nonprofits are good? Heavens no, it doesn't mean they're all good. And a lot of them are formed for the wrong reasons. We have too many people thinking that if I file a nonprofit, I'm going to convince everybody that I'm really doing well, and I can go after them for tax-free money and an IRS, a 501c3 documentation, so I don't have to file taxes. I can just raise money. Those things get caught up under your tax forms.
Yes and no. I mean, if you look at what's going on with all these political 501c4s, like they are.
Yes.
Yeah, they're only supposed to do certain things, and they're doing everything under the sun, including lots of stuff they're not supposed to be able to do.
But again, Bill.
And every time somebody goes after them, they get all kinds of political pushback.
Yes.
So the IRS is hesitant to do anything about it.
So it's really hard to say what should be and what shouldn't be. But when we talk about actually the first question I was going to ask you was, what are some of the legal technologies that impact the legal profession? Well,
right now, we talked about document creation, websites or programs that create documents for you. We also have the legal research. You can go online now and access up-to-the-date statutes and Google, whatever topic it may be. That's another one. A lot of people are able to do legal research online. There are even forms available online to help you litigate cases. And these, mainly deal with family law or very simple procedures like evictions and things like that. So there are some forms like do-it-yourself divorces and do-it-yourself eviction.
Well, let's go back and talk about eviction law just a minute, because this is a question we get quite often from people that call us at the office. Older senior citizens, they are just living on a limited income. They can no longer afford to pay the rent, so they are in danger of being evicted. So we have told, we've got several sources we can call, get people to help people that are faced with eviction, but what are some of the things that a senior citizen is facing eviction? What kind of thing might they fall back on to help them? Do you have any idea?
There's not much out there. No.
There really isn't.
Yeah, I mean, if you sign an agreement to pay rent and you don't pay rent, you've defaulted on that agreement.
Yeah. Yeah, we've gotten a lot of phone calls on that, and contrary to what a lot of people believe, there are no funding sources readily available to help people. I think the county will pay 1 month of rent, one month. Some of there's a St. Vincent de Paul Society. Most of the Catholic churches have those. They will offer some help, but
there's nothing long term.
Nothing long term, and when you get the area of homelessness and homeless housing, it's extremely limited, and there's just not much you can do. And if you make mistakes in doing some of this paperwork and filing, you can get yourself in that position quite quickly.
Well, that's kind of where I was going with this. If you are trying to do your own litigation and you're filling out the forms, that doesn't necessarily make you a great trial lawyer. It just means you know how to fill out a form, and hopefully you filled it out right. But when you get into the courtroom, there's a lot of other things that come into play, namely the evidence code and how evidence gets admitted and how a trial is run and things like that. So that, the civil procedure part of things.
I've had people call for advice over the years that are facing some of the situations, examples that you and I are just talking about right now, and I'll look at the case, and I'll look at what the attorney did for the defendant as opposed to what they did for the plaintiff, and I'll see where the defendant, the person that's trying to make something right, has got a very poor attorney, and the other people have just eaten them alive.
And can you imagine if you are your own attorney and you don't know anything about law?
Yeah, and then you get all objections, and anything you think is what really might help your case, if you don't say it the right way, it's going to get it inadmissible.
Right.
Okay, we got to wrap it up, folks. We're going to take our mid-show break. Stay with us. We'll be back in about 2.5 minutes.
WMEL.
It's the Talk to Me Network on AM 1510, FM 99.9, 94.7, and 100.7.
This is Joe Steckler, folks. We're back live for the second part of the show. I hope that you learned something from the first part of the show and you kept your pencil and paper out, because Bill's got a few things in this next part of the show. I think he might jot some things down, because they will help you. I honestly believe that. Again, the purpose of helping seniors is to inform, educate, and help connect seniors and those that care for seniors to resources. The phone number for Kay Kaiser, who is our information specialist, the information number is 321-473-7770. If people that are listening to the show, Bill, are profiting as much by the information that you disseminate to them as I do by doing a show with you, and the same with Lee Sheldon, the dentist. When I do a show with Lee, I thoroughly enjoy the show. I enjoy doing a show with you. We've been doing it for years. We can have light moments in the show. We can have some serious moments in the show. But the whole thrust of it is that if you can get information out to people that will help them and help them do things the right way, we can really do something. And right during the break, folks, I mentioned to Bill that we did a TV show on the same topic we're talking about. So if you go to the website, you can see it on our website. But one of the things we didn't really talk about as much on a TV show was that the do-it-yourself legal estate and real estate forms. And I think that if you could help our listeners understand some of the pitfalls in using those types of forms, Bill, I think could be beneficial to them.
Well, again, it goes back to what we were talking about earlier when we were talking about wills and other documents. A good example is a durable power of attorney. A few years ago, in 2011, Florida changed its durable power of attorney statute. So if you executed a durable power of attorney after October 1st, 2011, it had to have the person making the document had to sign off on certain types of clauses in the body of the document in order for those clauses to be valid. And, clauses included like to change beneficiaries on life insurance or create a trust, things like that. Well, a lot of these do-it-yourself forms were not updated. So we were getting people coming in the office with a power of attorney that was executed after October 1st, 2011, and there was no place where these people signed off on these powers. So that meant whoever you nominated to have those powers didn't have those powers. But you would have never known that until you probably went and tried to use your power of attorney. And when somebody's trying to use your power of attorney to manage your finances, that usually means you're incapacitated. And if you're incapacitated, that means you can't do a new document. So you find out a little too late to go correct the problem. And so that's the type of error that occurs. You are relying on the people who are producing these documents
to know what you want in there.
Not only to produce a document, when they first put them out, but also to update them for changes in the law. And that doesn't happen all the time.
Yeah.
I get powers of attorney in my office that are still like one-page documents. We haven't used one-page power of attorneys in Florida since like 1995. And the law changed in 1995. It said if you don't specifically give a power to somebody, they don't have it. So a one-page power of attorney where you say, I give the power to do anything I could do to somebody, that doesn't work in Florida and hasn't since 1995.
It's specifically stated.
Yeah, you have to give them a specific power.
Good. And you just mentioned something. Generally speaking, one of the most common element in a durable power of attorney, the most common element and exists in there has to deal with finances.
Yes.
And if you don't have the financial power to make or to enact what the person wanted you to do, if the person that gave you that power of attorney
has lost capacity,
has lost capacity,
or got dementia, they can't do a new one.
They can't do it. And then you are powerless to do what they thought you could do.
Yeah, the only way you could remedy that would be to go to court and become appointed as a guardian, and that's becoming a more and more expensive proposition.
We're talking thousands of dollars.
Yeah, $5,000, $7,500, somewhere in that ballpark.
Yeah,
just for an uncontested. If it gets contested, forget it. It could be much, much more than that.
And what would a durable power of attorney cost to prepare?
Roughly anywhere from $250 to $500.
And think what you save yourself. Can you imagine a person listening to this radio show? Very few people would realize how much time and effort it would take to correct the mistake that we're talking about.
Correct. And sometimes those mistakes are uncorrectable. You can't correct them.
Yeah, especially when you get into real estate law. If you buy, we have what we call real estate attorneys, and if you don't, you can get away. You might get away with making it. But I can remember something. My wife and we bought a home in Falls Church, Virginia, years ago, and had it not been for our real estate agent, we would have taken up. It was some kind of an insurance, so it had to do with. You know what I'm talking about?
Yeah, when you go to a closing, a lot of times you have to be, especially in Florida, most of our closings are done by title companies. Well, the title company doesn't represent you. They're just
title research.
Yeah, they just prepare documents, and they do get the title insurance is where they really make their money. But they're not representing you at the closing. And sometimes if you don't have your contract reviewed, you can end up with some very bad situations.
Yeah, we had somebody try to come back on us. It was several years after we sold the home, and we kept all the records, and we did have the title insurance, and so it was all covered. There was no problem for us. But I hate to think about what would have happened had we not had that title insurance.
Right.
So we don't always save a lot by not having insurance, and this type of insurance it does in a way have what we're doing. We're talking about estate planning. Talk about term insurance. Term insurance is very, very cheap. In this day and age, very, very few people have a whole life insurance. I'm not trying to knock an insurance salesman, but if you want the best type of insurance to get the more for your money, get term insurance.
Right.
Even you believe that, right?
Well, you do to a certain extent. There is a period usually in life when you don't need life insurance anymore.
Oh, yeah, I agree with that. Yeah. And generally those policies run out at, some of them run out at 70, some at 75, and some, very few last as long as 80. So,
going back to the, you were talking about the purpose of helping seniors of Brevard is to educate folks.
Okay.
Well, another thing that modern technology has allowed people to do is to go and educate themselves. And you were giving out our web address,
right?
So people could go to the website and look at the videos and things like that, which is a great way of educating yourself. But also, a lot of people look up legal issues, and whether it be litigation or legal, estate planning or incorporation or tax law or any kind of legal issue, a lot of people go online looking for the answers. And, the Internet's a wonderful thing, but as you probably know, you can find a lot of misinformation out there. You can find a lot of information that if you don't know how to apply it properly, it may lead you down some sort of path that you don't want to go down. So, there are some dangers with doing legal research. I had a case where I had a gentleman, we were doing a real property litigation thing, and he came in and he said, I found all this case law for you, and I want you to use this in the case. And I said, okay, and I took a look at it. Well, all the cases he had were from, Missouri and Kansas. Well, that's not precedent for Florida courts. That doesn't bind a Florida court as to the way they're going to rule. So, you really have to know that, states have jurisdiction over certain things within their borders, and state laws apply to those things. And then if you're in another state, the rules may be different, or if it's a federal law, it may encompass all 50 states. So it can get very confusing. And if you don't know how all that interacts, you may be thinking you're going to get a ruling one way, and you may get a ruling 180 of the way you're going.
What you mentioned that there was a rule change back in 2011. It had to do with a durable power of attorney. But are there any other big significant rule changes in the last 10 years that are allowed? Well, people coming in from out of state, second marriages, people coming in out of state. If you get tripped up using these forms, if you're in a second or third marriage, you could really mess your whole estate up.
Yeah, there are certain laws in Florida that apply to estates and are not. If I was in a second marriage and I simply said, okay, I'm just going to leave everything that I have to my kids, and you're going to leave everything you have to your kids, and I'll just write a will that says everything goes to my kids, and then I die, and we happen to be living in my house, which is, my homestead, but I haven't added my spouse's name to the deed, then my house may not go to my kids because my spouse may get a life estate in the house with the remainder interest going to my kids under Florida's homestead law. There is a law in the Florida Constitution that protects surviving spouses from being disenfranchised of the use of the homestead. So if you have a homestead that's owned any way other than as husband and wife, as a married couple, what we call a tenants by the entireties, then when one spouse dies, the other one automatically gets a life estate in the property. So even though my will says everything goes to my kids, my new spouse could claim a life estate on the homestead even if her name was not on the deed. Another one that my new spouse could do is she could claim an elective share. When you die and you don't leave a certain percentage of your estate to your surviving spouse, they can come in and claim it. And they file an elective share claim out of the courthouse, and they can claim up to 30% of your estate. It used to be that was on top of homestead. Now the law has just changed that percentage could include the homestead. So there's been some changes to that. But those are laws that if you don't know where to look for those laws, you can make some really big planning mistakes.
Well, that's the thing. We were talking, we go back to the title of the show, the do-it-yourself legal technology and forms. If you go in and sit down and talk to an attorney and you tell the attorney what you want, the attorney's brain is churning away at what you're telling him, but he or she is also churning away at what the implications could be if it's not done the right way. So the attorney can add an element to anything that you want to do legal-wise that could preclude you from getting yourself into further trouble that you don't need to get yourself into.
Correct. And you may not, you may have legally researched this and thought, okay, we just do some wills and I leave my stuff to my kids, you leave your stuff to your kids. But unless you know about the constitutional homestead law, unless you know about the elective share, you may be setting up your estate plan for big problems down the road.
Okay. A call we've been getting recently goes back to something you and I have talked about a number of times, and it sort of fits with what we're talking about today, but it goes back into the look-back period on when you're filing for Medicaid, and we're starting to get questions again about people saying, well, I'm going to go to Medicaid and I'll go do this to see if I can qualify for Medicaid. That law is up in the air so much every year that is there a safe way that a person could get back into Medicaid planning? And I know it's a great big ball of wax, but what advice would you give to our listeners on the Medicaid planning right now, Bill?
Well, we have to see what Congress does, and I don't even think Congress knows what they're doing.
Okay, I forgot about that too.
Yeah, they're handling all that. So, you can only plan with the laws that are in place when you're applying.
Okay.
If they change things, well, then they change it. But you have to go by what's in place at the time that you apply. And my advice would be to have a really good, durable power of attorney in place that will allow somebody to do whatever kind of planning is available at that time.
Okay, that makes good. That really makes sense.
Keep your options open. We don't know what Congress is going to do. They may create a per capita or block grant program if this thing goes through, and that would decrease, I think, Medicaid funding by something like 30% down the road here. Yep. So that would cause a severe constriction in people on Medicaid.
It goes to point out the fact that since we don't know what government is going to do from year to year, and it depends on who gets elected and who controls which house and all this stuff, it's still best for the person to prepare the documents, the right way, use the right documents, and put their plans in effect that will lessen an adverse impact by any administration.
And this is another great reason. Another thing you should watch out if you do it yourself is that laws change. And you should have your documents reviewed at least every 5 years to make sure they are up to snuff.
Yeah, I'm not getting the signal. I got to do that too, so I know I have to do it. And you pointed at me too. Folks, my wife is in the studio with us today. She's telling me I got to do that too. But, on the way home, we'll discuss some of the stuff that we've talked about here today. And I know that and that's what you should do, listeners. You should be discussing with your other partner some of the stuff we talk about, because two heads in this case are generally better than one.
I agree.
Okay.
I agree.
Bill, I want to thank you for being on the show today. How we doing there? You want me to keep talking? Okay. I woke Gary up. He's sound asleep at the control, but no, I'm only kidding, folks.
Well, I think the moral of the story is, to save a few pennies, you may create a bigger problem for you. So if you do have something that is bigger or more complex, it really pays to go seek a professional.
Yeah, and I have found that too, because I know that it's really a difficult time to make that. I want to thank Bill for being here with me in the studio today, and thank you, listener, for listening. Do take a look at our website. Take a look at the hot rod raffle car, because we depend on you to help us keep going. That's how we make our way through this world. So I'll see you next week. Bye bye.